Good morning, Masood. How are you? About what?
Loud.
Can't do much about that door. It's all right. It's so quiet in here. That's the only reason it seemed loud.
Ten?
Yeah. Surprising how a minute can drag out. I keep watching the clock. There it is, 10 o'clock. It's time. Good morning, everybody. How are you today? Good to see you. So there are some changes that are taking place July 1st, changes that have taken place April 1st. And then the biggest change we're going to have is if I ask you a question today and you decide to answer and you get it partially correct, in my opinion, then we're going to enter you into the drawing for the movie tickets instead of just giving them away. So maybe, just maybe we'll get some more participation. And that includes anyone that's out there remotely. So let us know you are happy to join in this. So the first announcement is August 13th, the MLS will no longer display a compensation field. So that is definitive right now. And then if you may not be aware, but the new forms releases occurred today. So that's something else, but there are certain forms that are anticipated to change and have not been released. And a couple of them are the most important, the residential listing agreement. It's still the same residential listing agreement that we saw before. And then the buyer representation and broker compensation agreement. That is the other critical form that has not been released. So you'll still be using the former buyer representation agreement if you're going to have something signed. There are other forms actually that haven't been released that were on the schedule to be released, but those are probably the most critical ones in regards to something you use most often. So I just wanted to make sure you're aware of that. What was that?
The open house forms?
The open house forms have not been released. But it will, and I think it's just because the Department of Justice has questioned the settlement itself and certain aspects of the settlement. That's what's now pausing the release of some of these forms that we anticipated to be released. And then beginning July 1st, can anyone tell me what the maximum deposit you can charge somebody?
Just one ring.
Very good. Very good. Exactly. So that's Sarah. Sarah gets an entry. And then together with that, there are some exemptions to that. If it's a small landlord can charge up to 2 months deposit. And it doesn't matter if it's furnished or unfurnished. And a small landlord is defined to be somebody that has no more than two new rental properties, of which there are no more than 4 total units. So 2 separate buildings, no more than 4 total units. So they're not subject to the 1 month relegation of a security deposit. But the exemption to that is if it's somebody in the military, even if you're a small landlord, they can only charge or assess 1 month security deposit for somebody that's in the military. So that's effective July 1st. Now, if you have current or somebody has tenants currently in which there is a deposit in excess of that, there's no obligation to return it at that point in time. So that's grandfathered in. But as time goes on, no more than 1 month's deposit. Yes.
How about like extra deposits, like pet deposit and those things? So would that be okay to be added to this?
No, it's not. As a matter of fact, the way it reads now, it doesn't say 1 month's deposit. It says value equal to 1 month's rent or 2 months rent. So am I putting up my motorcycle for my security deposit? So it's talking about value. And regardless, that's still all, if you call it a security pet deposit, it's all part of falling under the umbrella of 1 month's rent. So when you're speaking to your property owners, you need to understand, are they exempt? And if they are, they can charge up to 2 months. So it's a big difference. No more than 2 properties, of which there are no more than 4 units, 2 duplexes, for example. Anything beyond that, they're subject to only charging or assessing a 1 month's rental deposit.
What about the tenant to do the extension of the lease that they have to, they got security deposit over the 1.5 months. So the time is extension of the lease, they have to return it or just keep as the grandfather?
So my understanding is that's going to be grandfathered in. But once they move out, then I would say no further can you do that. But there doesn't seem to be any obligation, and that's a very good question, to return that excess deposit that may be there if there's a renewal or an extension of existing lease. I'd be more concerned about a new lease agreement being drafted, but if there's an extension, I think it's going to be grandfathered in. And the only reason I can think of why we would issue a new lease, and I'll talk about that later, but so often a lot of the new forms, especially the RCJC, have not been incorporated into that lease because we've witnessed people that have been in there 15, 16 years. And so the landlord is not aware that they have never drafted and issued the rent cap and just cause notification to the tenant. So it puts them in a very awkward position. We'll talk about that. And then some of the things we're going to talk about are existing law, and there's no change, but there are changes to just cause and rent cap. So in regards to what the rent cap is, remember, it's going to be equal to, if right now we're going to make the assumption everybody is subject to the Tenant Protection Act. And if you're subject to the Tenant Protection Act, you're subject to the existing guidelines I'm going to go through. In terms of increasing rent, if you're subject to the Tenant Protection Act and you're not exempt and you haven't filed the exemption, and I'm going to pause right there so I can point this out so everybody understands what the exemption is. Colonel, would you mind pulling that form up? On the rent cap and just cause addendum, we need to go a little farther. We want to go where the checkbox is. Maybe we all pass it right there. Okay. Oh, hold on a second. It doesn't want to stop there. It doesn't want to stop. All right. There. All right. In the box, notice of exemption. If this box, if you don't provide this form, and when providing the form, if you don't check the box in terms of notice of exemption, it's telling the tenant that you are subject to the Tenant Protection Act. It means all of the restrictions we're going to be talking about. But if you check that box, you're not going to be subject to the Tenant Protection Act. And that gives you the ability, for example, to increase your rent by as much as you want, to increase your rent as often as you want. And if tenants are added, to charge an additional assessment. Whereas if you're subject to the Tenant Protection Act, you're relegated to maximum rent increases in a 12-month period. You're subject to certain guidelines to terminate a tenancy. And if another tenant is added, you cannot increase the rent for the additional tenant. So the implications are pretty severe for any type of a landlord. So currently, if you're subject to, if you haven't checked the box, we'll simplify it. Notice of exemption. If you're not exempt, rent increases are subject to 5% plus a CPI increase. And we'll talk about the CPI increase. So currently, through August 1st of this year, that means a maximum of 8.8% annual rent increases, no more than that. If you're not subject and you check the box, then you can increase the rent by as much as you want. And then just cause, what does that mean? Just cause is the terminology that a landlord can use or under which a landlord can terminate a tenancy. So we're going to make the assumption once again, everybody's subject to the Tenant Protection Act. So there's only 15 reasons why you can terminate a tenancy unless you're exempt. So let's just continue on. We'll go into the details. And first of all, this does not apply to commercial property. As of January 1st of 2022, it does apply to personal property mobile homes, but only if they're owned and in a mobile home park. So personal property mobile homes, we don't work with that too often. Vacation rentals, 30 days or less, are exempt. And then typically, or the law only applies to tenancies of a period greater than 12 months. So vacation rentals typically are not subject to the Tenant Protection Act. And then remember, the law went into effect originally January 1st of 2020. Why is that important? Even that, though it was 4 years ago or more. Many times tenants have been on the property before that, so you need to pay attention to what's taking place. We just don't want to extend an existing lease agreement, taking the easy way out, because we're not going to be providing the necessary disclosures indicating, for example, that the landlord is exempt from the Tenant Protection Act. And then this form, RCJC, your zip forms, by the way. And when should you provide the RCJC? Well, if you actually issue a lease agreement, it's part of all the ancillary documents that are included. We just want to be sure that we're checking the box if the landlord is entitled to the exemption. So if the landlord has never provided that rent cap and just cause notification, have they lost the ability to exempt themselves from the Tenant Protection Act? And the answer is no. They still have the opportunity to provide the form, and we'll talk about how the proper delivery occurs for that. So if your tenant is month to month, does this matter? Yes, it matters dramatically, as a matter of fact. If it is month to month, the tenant may not be subject to, or the landlord may not have provided the exemption notice. And if the landlord hasn't, then they're subject to the Tenant Protection Act. And then leases. We should have provided the rent cap and just cause notice to an existing lease. But of course, if the lease was drafted before January 1st of 2020, it is unlikely that the landlord or any agent would have provided the RCJC because it never existed at that point in time. And then for new tenants or renewing tenants, always provide the rent cap and just cause form. And then let's see, the exemption. And we'll talk about the properties that this is applicable to and the guidelines for it, but theoretically, it is typically applicable to properties that are single family or separate alienable properties, a condominium unit, for example. It could be a separate apartment building, as a matter of fact, if the apartment building is 15 years of age or less. And then when you are providing the rent cap and just cause notice to a tenant who's on a periodic or month-to-month tenancy, what if they don't sign? What can you do? You can then at that point in time issue a notice of change in terms of tenancy, which is form CTT, and you can then attach the rent cap and just cause notice to the notice of change in terms of tenancy. And I'm going to give an example. If somebody's on a month-to-month tenancy and you want to increase the rent, you can do that through a notice of change in terms of tenancy. It's a 30-day notice. And this is another method to now apply and obtain the exemption if the landlord never has, if the tenant is on a month-to-month basis. So you would issue a notice of change in terms of tenancy, attach the RCJC, check the exemption box. 30 days later, whether or not the tenant signs, it becomes effective, just like a rent increase. The tenant could just willingly sign the rent cap and just cause notification, but they have no obligation to do that. Any questions about that?
Richard, who does say that you can do exemptions or not? So if I had an LCC, like the case that we were talking about the other day, it should be excluded or not?
Who's entitled to the exemption? Is that what the question is ultimately, Carmenza?
Yeah. Who? When we supposed to click on that?
Right. So individuals, and I'll go into further detail, but I'll answer your question right now, that are entitled to the exemption would be you, Carmenza, owning a single family home or a condominium and you're renting it out. So you're entitled to the exemption. If it is a family trust that owns the property, they're entitled to the exemption. If the property is 15 years of age or newer, and that's a rolling exemption, by the way, then the property owner is entitled to the exemption. If it's an LLC, the LLC is entitled to the exemption. There's an exception to that. And if it's an LLC in which one of the members is a corporation, then the LLC is not entitled to the exemption. So those are various reasons why you're entitled to the exemption. Does that answer your question?
Yes and not.
Yes and no?
Yes, I get that part, but if it's like a corporation who's going to rent, they supposed to be we supposed to click on the notice of exemption.
Well, if the property, in that case, if it's a corporation that owns a property, if the property is 15 years of age or newer, then it's entitled to the exemption. But if it's not 15 years of age or newer, then a corporation does not have the ability to take advantage of the exemption. But if it's
Okay.
an individual that owns the property, no matter what the age of the property is, they can take advantage of the exemption.
Okay.
And there's no limit in regards to how many properties that person can own.
Thank you.
Does that answer your question? If not, I want to make sure that I do, because you wouldn't be the only one that has questions about that. So now
Well-
other aspects in terms of being how it must be signed. If you're drafting a new lease, the lease together with the RCJC can be signed electronically. So that's not an issue. Or if it's an existing lease, can you force that tenant under existing lease to sign a rent cap or just cause a notice? Anyone want to tell me? We're ready. It's a simple, it's a 50-50 guess.
What was it?
The question is, if there's an existing lease, let's assume it's for a year, you're 6 months into it. Can you force the tenant to sign a rent cap and just cause notification showing that now we're exempt, that box is checked? Can you make them do that?
No.
No, that's correct. You cannot do that. Why? Because you cannot unilaterally make any changes to an existing lease. Who answered that?
I did.
Period.
Harriet. Okay, Harriet. So now, if the tenant is on a month-to-month tenancy, can you send the rent cap and just cause, first of all, a notice of change in terms of tenancy, and attach to that a rent cap and just cause notice form to the tenant electronically? No, you can't. It's not going to be valid if it's signed electronically. When you look at a notice of change in terms of tenancy, it specifies 4 different reasons in terms of presentation of that notice: personal delivery, post and mail, first class mail, something else, right? So if it's a notice of change in terms of tenancy from month to month occupancy, and we have the RCJC to attach to it, it must be signed in hand or by hand by both the property owner and the tenant. Tenant doesn't have to sign, excuse me, because it can just become effective 30 days thereafter. So if we're drafting a new lease, or we're sending an addendum to the tenant and the tenant agrees to sign it, although they have no obligation, we can send it electronically. If it's a month-to-month tenancy, we're going to change it unilaterally, meaning I'm going to change the terms of your month-to-month tenancy. I have to sign it as an individual, not electronically. And the same thing with the RCJC. If for some reason you have questions about delivery, we can certainly talk about that. And then in terms of rent increases, well, there's an odd guideline. So remember, if you're subject to the Tenant Protection Act, that means you can only increase rent by 5% plus CPI. And CPI is published from April to April of every single year. Now, if I'm going to increase my rent, the tenant's rent, before August 1st of this year, and that is the threshold, I must use the CPI from the prior year's April 1st date. Isn't that up? So if I want to increase somebody's rent on July 31st, it's the effective date of the rent increase, I have to look at the CPI index going back to April of 2023. As of August 1st of this year, if I'm going to increase the rent, then I can look at the CPI index for April of this year. And I'm going to simplify your life for you. Because right now, if anyone is increasing rent and the landlord is subject to the Tenant Protection Act, and you're going to increase that rent effectively before August 1st, you can increase rent by 8.8%. If the effective date of the rent increase beginning August 1st of this year is effective August 1st of this year, you can increase rent by 8.9%. So inflation was up. That's a real surprise. If you're not subject to the Tenant Protection Act and you're exempt from it, what is the maximum rent increase that can be imposed on somebody?
10%.
Very All right. There is no maximum rent increase if you're not subject to the Tenant Protection Act. So there's a big difference. And then in terms of how many times a year can you actually increase rent if you are not subject to the Tenant Protection Act? If you're doing it's a month-to-month tenancy. Anybody? Is there a limitation? There's no limitation, is that what you said?
Yeah.
Okay. Ms. Hood's got another one. So if you are not, yes, subject to the Tenant Protection Act, there's no limitation in terms of how often you can increase the rents. If you have an existing lease, you can't change the terms of the lease. But if you're subject to the Tenant Protection Act, you can increase rents no more than twice every 12 months. But it's still subject to the 8.8% cap. And that 8.8% cap is on a look-back basis. It means 8.8% of the lowest base rent that occurred during the last 12 months. So if I have rent at $1,000 10 months ago, and then I increase the rent 6 months thereafter, I have to base my 8.8% upon the initial rental rate of $1,000 before, to be sure that we're not exceeding that cap.
And what's the notice that you have to actually give them a notice? So what would be the minimum notice time, for them, for the tenants to know?
Okay, good question. So what is, those are good questions, as a matter of fact. So let's assume there's no cap. It doesn't matter in terms of what we can increase the rents by. What is the notice period for a rent increase of less than 10%? Anyone?
60 days?
No?
90
Less
days.
than 10%. Who said that in the background?
90 days, I say so.
No?
30 days.
30 days. Very good. Okay. All right. So we got another one. So if the rent increase is less than 10%, it only requires a 30-day notice. If the rent increase is going to be more than 10%, then it's a 90-day notice. And it's a 12-month look back when calculating whether or not we're in excess of 10% or less than 10%. But we know if you're subject to the Tenant Protection Act currently through July 31st, rent increases cannot exceed 8%, beginning August 1st, 8.9% annually.
Does that change if the tenant's been living there for longer than a year?
Well, actually, the Tenant Protection Act is not going to apply to somebody unless they've occupied the property for a year. So if somebody's occupied a property for 10 months, even though the landlord is exempt, are you subject to the just cause rules? Meaning, can I terminate the lease, or must I have one of the 15 reasons to terminate a lease? No. It's 12 months. That's when it becomes effective. And what if I don't increase my rent over the last 12 months? I'm a nice guy. Can I increase or double a rent increase next time? No, you can't. So that's unfortunate. So don't be a nice person. And then vacancy decontrol, meaning if the tenant moves out, even if you're subject to the Tenant Protection Act, are you relegated to an 8.8% increase? No. You can increase the rent to market rate rents when that tenant moves out. Let's see what else. And then we want to talk, I'm going to clarify those entities or individuals that have the entitlement to the exemption. Remember, even though you're exempt, if you don't give them written notification of the exemption, you're not entitled to the exemption. So it's very important that you manage that properly. So properties that can be exempt. Single-family homes or condominiums, so a separate alienable unit. And they're only exempt if the proper notice is given. So, and that means that it is not a real estate investment trust. So real estate investment trust is not entitled to exemption unless a property is 15 years of age or newer. If it's a corporation, it's not entitled. Limited liability company is not entitled if one of the members is a corporation. If it's all individuals, then they're entitled to the exemption. A duplex, there is entitlement to someone to the exemption, assuming they occupy one of the 2 units prior to leasing out the secondary unit. And the other aspect of that is it must be a single building. If it's a separate attachment, ADU or junior accessory dwelling unit, you're not entitled to the exemption. And in dormitories and some other things associated, if there's rent control and the guidelines are more stringent than the Tenant Protection Act, then you have to abide by the rent control policies. Co-ops are included also. There are co-ops in Laguna Woods, for example. Let's see.
Question.
We have a question? Okay.
For Santa Ana rent control, I can increase rent by 8.9% as well, Richard? Question mark.
No, as a matter of fact, and Santa Ana is a perfect example of rent control that's much more restrictive. You're going to be relegated to the more restrictive guidelines. And I think that's now in Santa Ana about 3%. I don't know the details of it.
I think about 5%.
It is?
Yeah.
Okay, I heard something less. There were some guidelines that came out. I think it's a terrible issue for any investors in the city of Santa Ana. Yeah, yeah. So if you have a tenant and the lease expires and the tenant never signed a rent cap and just cause notification in which you've claimed your exemption, when you're renewing the lease, and if the lease terms are somewhat similar in nature, it doesn't preclude a rent increase. If they refuse to sign the rent cap and just cause notice, then you can terminate the tenancy. Or if you allow them to stay in a month-to-month tenancy, then you can actually attach CRCJC to the notice of change in terms of tenancy and modify that month-to-month tenancy. But if they refuse to sign it, you don't have to extend the lease again. And once again, duplexes can qualify. So that means triplexes, fourplexes do not qualify. The owner does not qualify for the exemption as to the Tenant Protection Act. So that's a big issue. And if you rent out both units in a duplex, it doesn't apply either. Remember, the landlord had to live in one of the units first, and then followed by a tenant occupying the secondary unit. And let's see, let's move on to some of the other changes that have taken place here. So we talked about just cause reasons for termination. So if you're not exempt, there are reasons or at-fault reasons for termination of a tenancy, and there's no-fault reasons for termination of tenancy. At-fault reasons, for example, they're a nuisance, they're participating in criminal activities, waste, damage to the property, or maybe non-payment. So those are at-fault reasons. No-fault reasons include owner occupancy, where the owner of the property or maybe a relative wishes to occupy the property. You can't just terminate a lease. However, if it's a lease that's expiring, this is a reason to not renew the lease. Withdrawal from the rental market, so I'm going to sell the property. Substantial remodeling or demolition, and in compliance with the government order to vacate. So with that said, the guidelines are much more stringent now. Now, if you do terminate a tenancy based upon a no-fault reason, the landlord at the time of the termination has to notify the tenant of one of two things: that the landlord is within 15 days of the landlord terminating the tenancy, is going to write a check for 1 month's rent They call it relocation assistance. Or you can indicate that the last month's rent will be forgiven. If you don't do that, then the notice of termination is defective and it's not valid. Now, the car forms already address that. So you're not going to miss something like that. You just need to be aware of that. And then just a few different things. I just want to go over timeframes before we continue on in regards to the changes with the Tenant Protection Act. So timeframes. What are the timeframes in terms of delivery for a document if a tenant has not paid? What would you give them for non-payment of rent? Anyone? A 3-day notice to pay rent or quit, right? If it's a nuisance, you can give them a 3-day notice to quit. Let's assume they're disturbing all the neighbors or they damage the property. Or what if the tenant doesn't leave the property, even though they terminated the tenancy or there's a mutual termination, there's no notice required. And then if it's a month-to-month tenancy and I'm the owner of the property and I'm going to occupy it, or maybe my daughter's going to occupy it, or my parents, it's a 60-day notice of termination of tenancy. And if you're subject to the Tenant Protection Act, you're going to be paying 1 month's relocation assistance, for example. And then let's see now, so commencing April 1st. So let's assume I'm terminating a tenancy and my daughter may move in. How long does she have to live there? Well, before there was no occupancy requirement. So when I've had people tell me, when we know categorically they're subject to the Tenant Protection Act, well, I'm going to tell the tenant that I'm remodeling. It's not that simple anymore. There are specific guidelines. So if I own a rental and I am not entitled to the exemption, and I'm going to tell my tenant that I'm terminating the lease based upon the fact that myself or a family member may move in, it's going to require the following. You've got to identify the name of the person who's going to move in. They have to move in within 90 days. And if there's units in there that are vacant in a 4-unit building and there's a vacant unit, then it doesn't apply. As a matter of fact, you can't move somebody out. And if they don't move in within 90 days and use it as a residence for 1 year, once again, they're in violation. So there are consequences. And that is that the former tenant does not, let's say, I'm going to pass that up. So if the person that's scheduled to move in doesn't, the owner of the property must offer the unit back to the tenant who was evicted at the same rent and lease terms in effect at the time they vacated, and they must also reimburse the tenant for moving expenses. So the consequences are severe. If you're going to tell something that's not true and you don't perform, you have to contact the tenant to notify them their right to move back in, and the fact that you are obligated to reimburse them for reasonable moving expenses. So we want to avoid that. And then the owner must have, at least whoever's terminating the tenancy must have 25% ownership interest in the property. And then let's say, yes.
What about if they told them, I want to sell the property and they didn't?
Then I would say that they are subject to damages. They're subject to a recovery of attorney's fees. And also the tenant would have the right to move back on that property at the former prevailing rates that they were paying under the same terms that were offered also.
And he is 5 years, by the way.
Is it really?
Yeah.
Who wants to buy rental property there, right? It's just crazy. This is crazy. So we talked about the big change to the Tenant Protection Act in terms of claiming I'm going to move into the property or a relative is going to move in.
Question, Christine, how long does the owner have to live in the property?
1 year. 1 year. And Massachusetts said in LA, it's 5 years if they have to live in the property.
Wow.
Yeah, it's a long time. And then the other aspect that is a no-fault reason for termination of tenancy is substantially remodeling the property. And this is even worse now. So now it must require the tenant. Before, you could just say, I'm going to remodel it, and they can be in or out. There was nothing specific. So now the tenant must have to vacate the property for 30 days because of safety reasons. And also, if the remodel does not occur as scheduled, and once again, the landlord has an obligation to notify the tenant that the tenant has the right to move back in under the same terms that they previously had. Then also, we have to provide copies of the permits that are being pulled to accomplish the remodel, and we have to give that to them. A description of the substantial remodel has to be provided to the tenant also. And then a notification to the tenant that after the remodel is complete, if the tenant would like to reoccupy the property, they have the first right to do that. So I don't know if we want to get into any of that as a matter of fact.
Is it 10 or 15% increase in
For
rent with the renovation after renovation?
and what they're saying here, there is no increase. It's whatever the terms were in the prior existing agreement. Yeah, it doesn't make sense. That's why they don't want people using that as an excuse. Apparently it was used quite often. Then I'm going to remodel the property, you're going to move out. Now we have to provide evidence of the work that's going to take place and copies of permits, so on and so forth. So we've already had somebody in the past on the property that we leased on Corona Del Mar who has questioned the termination of tenancy and whether or not they were given an RCJC or given notice that the landlord was exempt. So it's people are become more and more aware of it, it seems like.
So to lease is better to buy.
Yeah, it's better to buy. Yeah. If you're a tenant, you've got all the rights in the world. So if a termination of tenancy notice is issued and it did not comply strictly with any provision of the Tenant Protection Act, is it still an effective termination notice? This is a layup, everybody. No. All right. Got another one. All right. If anything is defective, your termination notice when somebody is subject to the Tenant Protection Act or landlord is, then the notice will be defective and you have to start all over again. So that's my discussion today. Any questions about that?
I have a question.
What's that?
So you said on the duplex, if the owner has to actually live in one of the units in order to be subject to be exempt. First. Yeah. What if that changes like in the middle of the whole, tenancy agreement? Let's say they sign an agreement, like, tenant coming next, basically later on. And then right in the middle of it, the owner actually moves out and goes somewhere else.
They're no longer entitled to the exemption.
So, oh, okay, so he's automatically supersedes it, like,
Yeah, the exemption terminates at that point in time if the landlord moves out.
so he doesn't go for the full term. of that
No,
agreement.
no, it's going to terminate at that point in time.
Do we have to give him notice?
To my notice, I don't think I would give them notice.
Yeah.
I'm not aware of anything that suggests that we're going to give them notice, but I think the landlord's going to face that issue if they're trying to terminate the tenancy at some point in time when the tenant wants to continue to renew. And if there's no at-fault reasons for not renewing, then it could become an issue at that point in time. Okay,
Question.
yes.
What about if the landlord, they change the lease from yearly to monthly, but they don't want to give the tenants any paper, any document?
Well, you just can't change it unilaterally. The tenant would have to agree to that. So let's just assume that the lease expires
After the lease expires,
and the landlord accepts the rent payment.
yes,
It becomes a month-to-month tenancy automatically.
but without any document.
Without any documents,
Yeah,
right?
that's fine.
That's acceptable.
Okay.
Oh, yeah, yeah. Yeah, there's no problem there. It's just now you go from, if they're living or occupying the property for more than a year, then now, if you want to terminate it, it's a 60-day notice that the landlord must give, yeah.
In a situation that there is like in, let's say, a duplex or triplex, the tenants don't have any rental agreements in place.
Mhm.
But is still paying the rent. What would happen for the new owner to, like, new buyer basically buys the property? What's gonna happen then? You know, do they have to actually propose a new contract? They can increase it, they can do anything because they don't have any lease agreements in place to actually.
No, I would just assume, from my position, whatever the rent is they're paying, if they're paying $1,000, even the market rate rents are $2,000.
Yeah.
So the first thing I would do, if there's no documents, then it probably suggests to me that there's no rent cap and just cause exemption. Well, actually, first of all, a triplex, it's not even available anyways.
Yeah.
So from that perspective, you're gonna be relegated to today an 8.8% increase annually
Okay,
in terms of an increase in rents. You can have them sign a lease agreement, I would say at that point in time, in which the rent cap and just cause notice is included in there. If they refuse, you could terminate the tenancy. Or if they continue, just to allow them to stay there on a month-to-month tenancy, they could issue a notice of change in terms of tenancy. Attached to that a rent cap and just cause form. And then 30 days thereafter, the landlord is now exempt. And now if they want to increase the rent by 10% or more, here we got another 90-day notice. So it's a long time out before they can actually affect the rent increases that they want.
So, question. There's a question there. Percent, and if I refuse to renew the lease, can I raise rent until the tenant goes month to month?
Well, I guess the question would be, you just don't want to renew the lease? Is it just because you don't want to, like the terms of the lease?
Sounds like she just wants it to go to month to month.
I would say in Santa Ana, well, first of all, do you believe the landlord is exempt or not exempt? Yes, exempt. So the landlord is exempt. So I would assume that you have no obligation to renew the lease. You don't have to give any reason. Now, I don't know, I have to say, I don't know the guidelines in Santa Ana, if it's more restrictive than the Tenant Protection Act. I'm aware of the reduction in regards to how much you can increase rents, but is it more restrictive in terms of lease renewal? I'm gonna just guess the answer is no, but I can't tell you for sure. But let's assume it's the same as the Tenant Protection Act now that California has in place. Then there's no reason, if you're exempt, that you have to give a reason for non-renewal of that lease. So you can just say, I'm not renewing. And you're gonna allow it to go month to month if they want to stay.
and you can increase your rent, but once a year, so.
Well, yeah, in Santa Ana, that's a good question. Is it only once a year in Santa Ana now?
Everywhere is pretty much the same.
I see.
They can't increase it.
So Masood's saying in Santa Ana, you can only increase rent once a year there. As opposed to the Tenant Protection Act, you can increase rent by as often as 2 times a year.
Yeah. There's a cap.
See, but I would think if your goal is to get these people out just because you believe your market rate rents are lower, I would just be very careful about them perceiving that as being a retaliatory eviction. If they make a claim that whatever you're doing is because you want to get them out of the property, they may have a claim against you. So just be careful about that. But you don't have any obligation if you're not subject to the Tenant Protection Act to renew a lease. You can just allow it to go month to month. As a matter of fact, you don't have to give them a reason for termination of tenancy. That's a huge difference. Now in Santa Ana, there might be restrictions. So it would be good to know that, actually. Unfortunately, I don't know. Okay, I don't want the tenants out, but wish to increase rent because it's below market. So I think that could be an example of a retaliatory eviction. You just have the intent of wanting to get them out, but they may be protected from your efforts to do that. No matter what, you can only increase rent by 3%. And obviously, you're aware, smartly enough, that once, vacancy decontrol does not, or there is no vacancy control or decontrol in Santa, from what I'm aware of. And once they're out, you can increase the rent to market rate rents. So just be careful about that, because if they believe that that is your whole intent, you're trying to force them out or use other reasons to get them out, you could make a claim like that. Anyone else? Your own personal questions are always helpful. Okay. No other questions? All right. Well, thank you for coming today.
Draw.
What was that?
You're gonna draw.
Oh, that's right. We're gonna have a drawing. All right. This is gonna be a tough one. Masood. That's funny. Actually, we have two drawings.
Pursuit.
Anyone from the audience remotely could have participated. And Sarah Park. Okay. All right. Woo-hoo.
Thank you, sir.
Thank you. Okay, so remember, July 1st, all this goes into effect with the Tenant Protection Act. And effective today, the new forms have been released. And August 13th, if I have that date correct, that's when compensation will no longer be offered on the MLS. So the suggestion is to get your buyer representation agreement signed. Otherwise, you may not be protected at the time that changes if you don't have an accepted offer. And there's no more compensation offered on the MLS. Jay and Sarah just had one. They're offering $1 on the MLS for property they made an offer on.
I have one, actually, buyers paying me.
You do? Okay.
Yeah.
It's already happening. It's not taking long, is it?
Certain things real estate agents move very quickly, Richard.
It's surprising how many people are, too, the actual clients themselves, thinking, I don't want to pay, but if they're moving somewhere, they don't want to pay either. It's kind of funny. Thanks for coming, everybody.
Thank you.
Thank
Thank
you.
you.